Hello, everyone. I'm Ronald, this year's chair of the CIArb East Asia Branch Young Members Group, and it is my pleasure to welcome you all to the first in a series of 8 webinars. In lieu of our second annual conference, I'm glad to be able to kick off the series with this very interesting panel and topic. One of our goals this year in the YMG is to put the young ADR practitioners in the forefront and put them in the limelight. And I think we have really achieved this with the series of webinars. In particular, this year, YMG wants to highlight the adaptability and versatility of our young members, and hence this panel today. Before I introduce today's moderator and hand it over to him, I would like to take an opportunity to thank all the organizations who have helped make this series of webinars an obvious success. I would also like to thank Jay Santiago, the chair of the Philippines YMG chapter, for doing such an amazing job. It's already difficult to organize one physical event, but to be able to pull off 8 webinars with more than 40 panelists spanning across the globe, it's a great feat and nearly impossible to do. Sometimes I wonder how much sleep Jay actually gets, because he seems to be up all day, all the time, 365 days a year. I would also like to thank his team at Christenberg Torres, in particular Daniel Lim, who has had the unenviable task of chasing each panel of webinars, organizing all the logistics, sending out the emails during all times of the day. Again, I have to thank her very much for helping us out. And now moving on to the highlight of the day, our first webinar series. Today we have invited a wide range of panelists with a wide variety of experiences around the globe, from the UK to Nigeria, from Africa to India, from Singapore to Geneva, all of whom are well experienced in the field of ADR and have great experience to share with all of us. I will leave it to the moderator, Damian, to introduce him individually. Now to the moderator, Mr. Damian James. To those involved in construction disputes, he needs no introduction. To the rest of us, Damian is a practicing expert who has been appointed in various disputes around the globe in both arbitration and adjudication. He has acted as an expert in disputes involving delay, disruption assessment, quantum, and cost evaluation. He has also great experience involving with different types of construction contracts, including JCT, FIDCT, and ECT contracts. He's also done disputes involving bespoke construction contracts, and he's been recognized by the Who's Who Legal from 2018 to 2020 as a leading delay and quantum expert. I'm excited to be part of this webinar today, and I look forward to hearing everyone sharing their experience. Thanks, everyone, and have a good webinar. Please, Damian, if you may.
Thank you, Ronald. Thank you to our chair there for those kind words, and thank you for the opportunity to attend today and to moderate this panel discussion. The warmest of welcomes to everybody joining us from all different parts of the world. It now falls upon me to moderate today's panel in our discussion titled How to Navigate the International Waters and Develop an International Practice in ADR. Before I introduce our panel, and just picking up on Ronald's introduction, I predominantly act as a delay and quantum expert in construction disputes, but as many of you will probably have experienced yourself, I have a first degree in surveying, a second degree in law, and a master's in construction disputes. So I do sit as an arbitrator, both solely with a main focus on technical disputes allied to quantity surveying. And I do sit within tribunals of a 3-man panel where I take great joy and pleasure from being the non-lawyer in such panels. And from finding myself as normally being one of the youngest people in a moderated panel, I now find myself being one of the oldest. So thank you very much. My esteemed colleagues join us from worldwide locations today, and from what I have read, have practiced in over at least 7 jurisdictions, and in no particular order. We have with us today Miss Janice Lee from Singapore, who works for the Harry Elias Partnership. She's a multi-qualified international arbitration counsel. And Janice represents clients in their cross-border disputes involving commercial contracts, M&A, construction and energy. And she's particularly well versed in the SIAC and the ICC arbitration forms, and specializes in complex high-value disputes across multiple jurisdictions. Interesting facts about Janice is that during lockdown, she bought herself a huge puppy, and hopefully in the best traditions of all things virtual and webinars, the huge puppy makes a appearance today somewhere in the background. We're then joined by Mr. Isaiah Bozimo of Broderick, Bozimo and Company in Nigeria. Isaiah is a partner at Broderick Bozimo, which is a niche arbitration and litigation firm in Abuja. He has represented state-owned entities, corporations, and high net worth individuals in several complex disputes, both in arbitration and litigation. He's been involved in arbitrations under the rules of the ICC, UNCITRAL, and the Lagos Court of Arbitration. Not only is Isaiah one of the best dressed arbitrators I have met, he is also a former bronze medalist in the National Jiu-Jitsu Championship. We then move on to Ms. Leyou Tameru, who joins us from Ethiopia. Leyou is a legal consultant and she's the founder of the I-Arb Africa, which is the first online portal for arbitration in Africa. She's an expert in Africa-focused arbitration and a court member of the ICC in Paris. She's also on the board of directors for the African Association in Kigali, and she's on the advisory board of the MAR Arbitration Centre in Mauritius. She's also a member of the advisory committee for the rules amendments at the International Arbitration Centre in South Africa. And for those of you who've been following recent developments at the Society of Construction Law, which operates across the world, and we're here sponsored by the Society of Construction Law in Malaysia, you will note that the AFSA rules have just been amended in order to develop the international practice within South Africa to allow the South African rules to be adopted in more international disputes. A lot of my work focuses in Johannesburg and the areas of Africa, so support for AFSA is very important, and I thank Leyou for her involvement. Interesting, Leyou is another lover of animals, not to the same extent that she has a huge copy of Janice, but her interesting fact is that since the age of 4 years old, he has wanted to be president of Ethiopia. So watch this space, and with the US elections coming up, maybe we should just watch what happens in the future Ethiopia elections. We're then joined by Tran Thang from Switzerland. One is a senior associate with Peter and Kim in Geneva, and she practices international arbitration, which covers both investment and commercial arbitration. She has acted as an arbitrator, counsel, and an assistant to the arbitral tribunal in over 30 arbitrations, which have been conducted under various rules, and they range from ICC to UNCITRAL to the CIA, HKIAC. And she's worked across a variety of disputes. She's developed a particular expertise in energy-related disputes. One is a current member of the advisory board and regularly speaks and publishes in the field of international arbitration. One was schooled in Switzerland and the USA, and he currently speaks 4 languages, and she's now currently learning a 5th. We then have the pleasure of Dr. Kabir Duggal, who is a senior international arbitration advisor, and he joins us from the USA. And thankfully, he's based in New York, which is the city that never sleeps. So he's going to run right through here, despite the fact that it is 3 a.m. at home for him. Dr. Kabir focuses on international investment arbitration, commercial arbitration, and public international law matters. And he serves both as a counsel and arbitrator. Dr. Duggal is a lecturer in law at Columbia Law School and teaches international investment law and arbitration. A course director for the Columbia Law School arbitrators, a comprehensive course on international arbitration. As you would expect, Dr. Duggal has published over 40 articles and has spoken at over 300 arbitration events all over the world. He is a graduate of the University of Mumbai, a graduate of the University of Oxford, the New York School of Law, the Leiden Law School, and he's currently pursuing an SJD degree from Harvard Law School, which the interesting part of this is that I didn't quite understand what an SJD degree was, and I thought that with Dr. Kabir already having a PhD in suitable qualification, I was shocked to discover that his latest qualification he's embarking on is as a Doctor of Judicial Science. So good luck to you, Doctor. Finally, from India, we have Anish Wadia, who is a fellow of the Chartered Institute of Arbitrators. He's an accredited full-time independent international arbitrator and mediator. Anish has experience in common civil law jurisdictions within Hong Kong, China. He's a qualified lawyer in India, England and Wales, and Kazakhstan. Interestingly, he's also an accredited sports arbitrator with the AIAC and the Olympic Council of Malaysia. Anish is regularly appointed as presiding sole emergency wing arbitrator and mediator under the ICC rules. and the HISA. And he also works within the KIAC rules, which is Rwanda in Africa. He works across a broad spectrum of disputes and is often invited to be a speaker and a trainer at many international arbitration and ADR events. Most recently, he had the pleasure of providing training for the Bahamas Supreme Court. Unfortunately, that training was done virtually. Anish's desire to be a lawyer had its genesis pre-birth, when his mother's friend predicted, "Susan, with the amount of times you keep coming to court, your child will end up being a lawyer." And here he is today. Thank you very much to all of our panel for joining us today. We are among some very, very distinguished ADR practitioners across the world. And it's an absolute pleasure to see you all here today. Thank you very much. Before I pose some questions to the panel, and the process of today is to allow the panel to speak to you as much as possible in an anecdotal format and in a formal, informal format, or however they choose. We will take questions in the last 15 minutes. So do feel free to place your questions in the Q&A session, in the Q&A box. And from there, I'll look to filter them so we can answer as many questions as possible. Okay, so in terms of our topic today, I guess the elephant in the room is the biggest question and the most common question for any aspiring ADR practitioner. And ordinarily it follows from those years of study with LLBs and LLMs and professional memberships of different bodies and virtual learning, etc. There's a plethora of accreditations that we all tend to take and place ourselves out there and say, okay, I'm here as an arbitrator. But I'd like to direct the question firstly to Janice. And that question is, in simple terms, how do you get onto that first tribunal and where does your appointment come from?
Hi, thanks, Damian. Thanks for starting off this this discussion. And I guess before I begin, I'd like to thank everybody who has joined in to this webinar. And we've prepared a very great session for you. And I really hope that you find this very enriching and inspiring as well. Personally, I do think that there are a number of barriers to many people achieving their first arbitral appointment. But that being said, I don't think that it should be something that should discourage everybody if an arbitration or a career as an arbitrator is something that they do want to pursue. In terms of, what are the ways that somebody can secure that first arbitral appointment? Of course, conventional wisdom, or at least the wisdom in a lot of arbitration circles, would encourage you to do the usual track. You network a lot. You put yourself impaneled in many different institutions. For example, I was previously also an associate counsel with the Singapore International Arbitration Center. And one of the very admirable things that the center has done is to have a reserve panel to encourage younger arbitrators or arbitration practitioners who may not have had yet their first arbitral appointment, but who are recognized as competent practitioners. They may be younger, less well known, but no less competent or qualified. So these are some of the things that a person can consider in order to be, to secure their first arbitral appointment. Other than that, of course, again, conventional wisdom would dictate things like, other than networking, being impaneled, you also would like to be able to strengthen your intellectual profile. You can write articles, you speak in, webinars and webinar series, such as this particular one, very renowned webinar series. And all of these things would increase your profile. And the reason we want to do that is because when, for example, an institution or even parties look to appointing an arbitrator, they want somebody who is known to be competent. Most of the time, it won't be somebody they personally know. So the only way they can look for your qualifications is by the things that you have done. So you want to build that kind of network, that kind of persona and profile around you that ensures parties, when you have been appointed, that you're somebody who's qualified, who's competent, obviously somebody who will be impartial and will be able to decide the case, properly. And of course, it doesn't hurt to be members in other institutions or other organizations such as CIArb and PIArb, both of whom are, helping us with this webinar series. All of these build up your skills. All of these build up your network and your profile. And it really is the foundation upon which you can launch an arbitration career. Other than, of course, I would say that the basic baseline would be really, there's no going around it, hard work. So I think for me, that would be some of the ABCs of securing your first arbitral appointment.
Okay, thank you very much, Janice. I think the message is quite clear there in terms of your intellectual profile and encouraging confidence in your abilities, both from a judicial point of view and from an emotional point of view. And I think that's an important message for all of our attendees today. You did talk of the CIArb there and the other professional bodies, and I'd like to bring Anish in here now, because Anish, you are a well-written and well-published arbitrator across the world, across the international platform. I did notice in one of your interviews with the CIArb some years back that in your opinion, in terms of the platform, you should look no further than CIArb. So I think my question to you is, how much of a platform, or indeed a stepping stone, and we're keeping with the theme of the international waters and the analogy that we have there, how much of a stepping stone is the CIArb to an aspiring practitioner, and how can they make the best use of that?
Thank you for that question, Damian, and of course to the organizers for having me here today. You're right. When I gave the interview, for me, if you look at my profile being accredited as a fellow of CIArb to post being accredited, it all changed for me there. Now, that does not mean that other organizations out there aren't equally good and provide that training. But today, if you look at the majority of international and the world's leading international arbitration institutions, where you would seek to get impaneled as an arbitrator, de facto, each of them say, as one of the criteria, are you a fellow of CIArb or another equivalent body? So CIArb is generally considered the preeminent training and accreditation body in the field of arbitration, mediation, and adjudication. And for me, it started there. And like I said, I used that as a starting point, but not my end point, because I then accredited myself by 12 other bodies in different jurisdictions, including South Africa, in Europe, I'm a fellow of PIArb in Philippines, in Malaysia, Hong Kong, and many other jurisdictions. Because what this does is, like Janice and you said earlier, people who generally tend to appoint, they don't know who you are. People need a sense of comfort. I'll give you an example. I was appointed as an arbitrator in a dispute in Kigali, Rwanda, though I have never traveled to Kigali, and though I haven't had, prior to this case, experience in Rwandese law, which is a blend of Belgian and German customary law. And I'm a common law qualified lawyer. No Indian parties involved, no Indian parties, nothing to do with Indian law or common law. It's between a state entity and a foreign investor, but yet they chose me because they felt a sense of, I'm assuming, comfort to see that, okay, look, we have an individual on the panel over there who's qualified in many Asian jurisdictions and other jurisdictions. So they have a sense of understanding of the different cultures, because I think it's so important today. You mentioned about, Janice spoke about hard work. You speak about accreditation, intellectual, etc. What's equally important is cultural appreciation today. Because today in international arbitration or even in international commercial mediations, it's so important to appreciate and understand the different cultures, to appreciate and understand that for an effective conduct of an arbitration, it's not only important to understand the dynamics between the parties, but also dynamics between your tribunal. Because if you cannot manage your tribunal effectively, if you cannot understand how someone from Palestine or an Israeli arbitrator would react to each other along with you, you may sometimes need to play the peacemaker. You may sometimes need to balance things out between genders, not be linear in your approach. I once, the other question that often arises is, and it's a very Asian and perhaps an African mindset, an African cotton mindset, to say that oh, if you're sitting on a tribunal today as a younger practitioner and our co-arbitrators are significantly senior, retired justices or chief justices of the Supreme Court or the High Court, the general tendency, and Isaiah also once said that, I'm sure he'll have something to add to this, or Leyou, that we tend to accept the general mindset, that accept what our seniors and the elders or the retired justices are saying without questioning. That has been the historical mindset. But it's important that we hold our own ground, be firm, but at the same time very respectful. Often at times it's important where you let that senior individual perhaps take credit for something efficient that you have done in an arbitration, to bring about that balance and that pacification to your senior members of the tribunal, because sometimes they may, it's difficult for someone who's in their 70s or 80s to have, let's say, someone in their late 30s as a presiding arbitrator. Right now, I'm sitting as presiding arbitrator in a tribunal with a former very senior justice in their 80s and another very senior arbitrator in their late 70s. And it took a lot of work on my part to build that trust, to build that respect, so they feel comfortable. And I think that's also important to keep in mind.
Thank you very much. So I think what you are saying is that, picking up on what Janice had said, the CIArb can be pivotal in your journey, but then your own development must be accompanied by your own fortitude and endeavour and respect, and you must embrace your position in the arbitral forum and develop accordingly. And I think that is a point I really, really like, and I do appreciate that, Anish. I'd like to push a little bit further with Leyou, because for me, Leyou, you find yourself in what seems an unenviable, or actually an enviable position of age, ethnicity, and gender in entering the world of ADR. And I think my question really, if I can phrase it correctly, as a young woman in the field of ADR who's clearly excelling, is age, and picking up on what Anish has said there, is age, ethnicity, gender, race, is it a myth or is it a reality?
Thanks, Damian. Well, it's a very interesting question, and I'm glad we're addressing it from the get-go, because it's definitely something that comes up when I'm around, particularly. I'd be introduced on panels sometimes. I remember when I first got appointed as a court member at the ACC, I had the moderator introduced me as, the ICC is doing a fantastic job at diversifying. The president's doing a great job at diversifying, and here's Leyou Tameru. So which kind of makes it sound like I'm a diversity appointee, which is really definitely something that comes up a lot. And it's no, I just happen to be these things, and the fact that I am a young woman from Africa, and the racial issues and the white old boys club that is the International Arbitration Club, we have to work 20, 30, 40 times harder to be able to even be noticed. Not even get appointed, but just even get noticed. And I like the fact that you started the question with how to secure your first appointment. I've done a lot of work. I've negotiated with governments. I've worked with private investors and whatnot. And I am yet to have my first appointment as an arbitrator. So it's still a struggle. You could be fantastic. You can have a great profile, but when it actually push comes to shove, it's, do we really trust her though? I mean, she's really young, and does she have enough experience? And it's a very interesting, and I completely understand, having worked with different clients, I understand where the challenges come from, but it definitely is a reality. And it was just recently announced, I remember there was actually a research that was done about how, the number of women arbitrators being appointed, or, women arbitrators being appointed in different arbitration centers. And it's interesting. And you would see that within that, it's not just, it's women, but it's white women, and it's white women above a certain age, right? So it's definitely there. And I'm living proof that it's definitely there, but the only thing we can do, and what I've done so far, is to consistently stay present and consistently keep working and publish and read as much as possible. And I think it's always interesting to see people underestimate you, which is fantastic, because then you have the power to over deliver, which puts you in a very good position. So yes, it's still there. It's still hard, but here we are.
You make some very, very strong points there, and I really like the commentary, or the stay present commentary. I think that's excellent. I think that's something which is a real takeaway for our attendees today. It is important to stay present and stay in that moment. And you mentioned the White Old Boys Club, which I'm sort of getting to that age now, and that White Old Boys Club is incredibly difficult to get into. So, you know, I think I need to, whereas, you know, a gentleman my age might start dyeing their hair to lose the greys, I think I need to dye my hair grey in order to make that step up into that next club. And the other point you make, which is really interesting, is that, you know, you don't want to be a diversity appointee. You don't want to be a tick box exercise. You want to be taken for your worth and your value. And I think that's a really, really strong message. You know, and I'm not sure how you'd feel about resisting certain appointments or taking appointments on that basis. And, you know, I'm not sure where that situation would arise, but maybe, you know, you might find yourself with two white grey-beard tribunal members, and you feel that you are the diversity appointment. I don't think that's a message that you would necessarily project onto the audience as well, because I think you are saying that staying present and being the person is the most important thing, and your conduct in the arbitration will see past that as well. So I wanted to bring one in now, because one, you have, looking at your profile, you joined us today from Switzerland. You've actually grown up in two of the major international hubs. And I also read that you've had experience in London as well. So really that's three of the major hubs: Paris, Geneva, and London. And I think my question of you has two parts, really. In those hubs, and taking a little bit of what Leyou says, you know, the acceptance of the existence of the arbitration mafia, or the prevailing arbitrators, etc., means that there is lots and lots of competition. You know, do you start your career in those hubs? And the second part of my question is, what do you think of the use of the virtual training and hearings on an ADR career? Do you think by not starting in the hubs of Paris, London, and Geneva, that the virtual scenario is going to help that process? Do you think that you should start as a young practitioner in another jurisdiction? What do you think about that, Ron?
Yes, thank you, Damian. Yeah, I think that my perspective is very much the one from someone who grew up professionally in arbitration hubs. As you said, it was Paris, London, Geneva, London a little bit, and Geneva. And I see a lot of students coming to study in Europe to try the same as me. But I think for us who grew up professionally there, the fact is that when you arrive on the market, there are tons like you. I mean, there are tons who did the same university, the same trainings in the same law firms in the same cities. And so I believe that first, for people who come from less developed jurisdiction in arbitration, they should try. I know that it's also very difficult, because also not so long ago, you had to travel, to fund yourself, to come study in Europe, then secure internship, and then face the same competition as everyone else in these hubs. And sometimes it is much more difficult for you when you come from abroad to get the internship and the professional experience because of the permits and so on. That being said, I think that, you know, aspiring arbitrators coming from these less developed jurisdictions should also see and be reassured that they are most of the times more unique than us, because they have a different background, they have different languages, and I believe that languages are sometimes a criteria to hire people, you know, and definitely a criteria to appoint arbitrators. And the more rare the language you have, the better the chances they're going to play a big role. For instance, I remember that Noah Rubins was always saying that his first appointment was because I think it was ICC or another institution was looking for an arbitrator speaking both Russian and Hebrew and being very knowledgeable in some field that he was in. While there were not that many arbitrators speaking these two languages, I know that, for instance, there are clauses who say we want that nationality, but someone who's trained in another system, for instance, French Swiss happens sometimes, As to the virtual aspect, I think that this is a chance to seize now for everyone. For instance, I'm someone who's mostly interested in webinars taking place in Asia and that cover some Asian issues on Asian markets and some new treatises. But before I could, for instance, like in 2019, I went once in Asia. I did like a lot of conferences at once, and then I went home, and then probably for a whole year, I don't go back. Right now, I can attend all these wonderful webinars, for instance, from the CIArb Asian chapter, like today. And I think that the people who are in less developed jurisdiction nowadays, I mean, you see them much more in webinars, you see them participate, so it also enriches the conversation. On that end, I think it's a great thing. Now, the people who are younger in their career and they still need to go through LLMs and they want to do internships, because it's true that also having a short professional experience in an arbitration hub and then going back to your jurisdiction is probably a big help in your career. That is difficult because, yes, today it's not possible. But let's see the positive aspect. You know, I know that some firms are doing virtual internships. I know that Hajatan was doing this in Singapore. I know that Sherman and Sterling, some people are interning virtually right now. And actually, in all the law firms where it's there is a lockdown, like right now again in Switzerland. So try to take advantage of this time. You know, it's a challenging time, and I also appreciate that the people who were doing LLMs in 2020 have seen their LLM go virtual, probably with a lot of disappointment. But try to go to all these webinars as much as possible. Don't get swamped at work so much that you don't take the time to at least, I don't know, maybe twice a month, try to be in a webinar, try to chat with people and to continue network from these hubs. Think that you have access to more things in a way than before virtually. So I think we all need to take advantage of this, and especially the people who were, I don't know, dreaming of attending this or that webinars, of mingling with people who are always at the ICA Congress and big conferences, but not in their region. Now is your chance. I think we need to stay positive.
Thanks, Wadia. Another important message. Discussion there in respect of having another language, another culture. I definitely think it does help with the understanding when you work on an international basis. And my work in Africa has, you know, my actual practice in Africa changed very, very quickly once I understood that appreciation of other cultures and other languages is very important to the whole process and the whole dynamic of it, so that you're not seen to be preaching and, you know, you are almost selling rather than telling in that approach, that you are always amenable and you will understand people's different connotations that they take from different words and different structures and sentences. So I think it's very important, the language skills as well. Isaiah, if I can bring you into the conversation now, and perhaps we can just roll the clock forward and just address the position that one of our aspiring practitioners may find themselves in, and they get their first appointment. They then find themselves sitting with an eminent judge or retired judge and a Queen's Counsel from different jurisdictions, but both with white beards and years of experience. Isaiah, how do you find your place in your role in the tribunal? And whilst you need to command respect to the tribunal member, you also need to maintain respect to your co-members. How do you balance that whole exercise when you find yourself at your first tribunal?
Damian, thank you very much for that excellent question. And before I answer, let me also thank the organizers for putting on this event, and thank everybody for attending. So before I answer your question, let me sort of situate it in the Nigerian and African context. So I re-echo pretty much what Leyou was saying in terms of, and what other speakers were saying in terms of how difficult it is to break into this club, right? So imagine yourself as a young arbitrator, and if you look at data from the SOAS 2018 Arbitration in Africa survey, you will find that 82% of the respondents hadn't taken part in an international arbitration as arbitrator. And perhaps more surprisingly, 58% of respondents hadn't taken part as an arbitrator in domestic arbitration. So primarily, it's very difficult to break in. And when you do eventually break in, you want to ensure that you don't muck it up. So you have repeat appointments. Now, imagine you are a young arbitrator, first appointment, tribunal of 3, and you are with these eminent jurists, eminent arbitrators, and you want to make a very good first impression. Again, look at it from an African context, and I suspect it's the same in other developing jurisdictions. But from an African point of view, you have this situation that respect for one's elders is paramount. And one's elders can, in that regard, impose their views on you and expect to say yes, and expect you to say yes. I'll give you an example. I was speaking yesterday on the telephone with a very senior Nigerian arbitrator, and I've appeared before him as an arbitrator before, as counsel before, and I'm currently sitting with him as a co-arbitrator. And we were having a conversation in the context, not in the arbitration, but in terms of an event we were organizing. And he proposed we went a particular direction. And I questioned each thing he said. And he called me up immediately and said, listen, in my day, if I told a youngster something, they would tell me, yes, sir, yes, sir, yes, sir, I agree with everything you say. So the question becomes, how do you then sort of pacify this expectation? Well, you have to do it with tact. You have to be very respectful. So the way I did it was to say, well, I'm only doing what I learned from you each time I appeared before you as counsel before a tribunal, and when we converse as co-arbitrators, these are exactly the views you express. So I think primarily you have to demonstrate to your senior colleagues that you deserve a place at the table because you have to command respect. And you command respect not by sort of going in there and saying, well, I know it all. It's by actually demonstrated. So if a point of discussion comes up, you respectfully table a point forward and you make it very clear that this is the direction you think it should go. And I often tell colleagues that I'm speaking with is the more simple you can make the argument, the more persuasive it is. So you put a point on the table and it's just obvious that that's the situation. Imagine trying to argue with somebody that 1 + 1 = 10. You will have a very difficult time trying to persuade somebody. But if you just lay it down on the table, this is a very simple argument. This is why I think we should proceed this way. And this is why I think that the other position is not the one we should follow. They will tend to listen to you. And like I say, if you make it as simple as possible, make it in a way that they can't really answer in a way that deviates from your point of view, then they will tend to follow your analysis and in the same time respect what you say, and your reputation starts to go up. So the long and short, the short answer of it is be tactful, be very respectful, but stick to your guns and demonstrate that you know what you're talking about and you understand the law and you understand the process. Eventually, you will turn your colleagues into your fans, and they will start recommending you for other appointments and other either as counsel or as arbitrator.
Thanks, Isaiah. I think there's a lot of fans just with that commentary there. Thank you very much. I think I'd like to bring Dr. Kabir in now, just to pick up on a number of points that Isaiah made, and also what Anish touched on earlier. Obviously, Kabir, you are, and thank you once again for joining us at 3 AM. It's no unenviable task, that one. You are extremely well qualified in legal practice, and you may immediately warrant your co-members' respect because of those qualifications. And as I just touched on the fact that you, in the academic legal arena, you are taught by some very eminent judges and some very eminent professors, etc. You are taught to question. How do you balance the judicial knowledge and expertise with the cultural, religious, and the ethnicity differences between you and your tribunal members?
Thank you. I mean, that's a great question. I don't look at these options as being mutually exclusive. I think there is the IQ and there is the EQ. And to be successful in life, you need to be intelligently smart, but you also need to have this emotional quotient. And to that extent, having one but not having the other seems to me to be the perfect recipe for disaster. You can be very smart, but if nobody likes you, your career isn't going to go very far, right? Now, for the young people in our audiences, right? People who are looking to make their career, this is the advice you're typically given, What do I do when I go for an interview? And we always tell people, be yourself. Be a more polished version of yourself. It is an interview, but be yourself. And just on that point, right, what is a good test for somebody who is applying for a job? The two things that I'm looking forward, point number one, you are not a serial killer. Once you have crossed that threshold, the second point I want to know is, if we're working together at 2 a.m. in the morning, would I like to have a pizza with that person? And I think the same thing is going to apply with an arbitrator. You're going to appoint an arbitrator that you like, that people can tolerate, that people perceive to be fair, sensible, thoughtful, all of the wonderful adjectives, right, that you want to see in somebody who's going to be a decision maker. So I look at both of them being very important. I may actually take it one step further. Academic credentials help, but they're by no means prohibitive. You can still have a good career if you don't have the academic credentials, and people, for a variety of reasons, may not have the opportunities that some people have in life. It can be cost, it can be placement, it can be personal situations. You can still make a very great career, and you can be very successful if you have this emotional quotient. Now, I should probably stop here, but I will make one final point. And this is particularly significant to the younger generation, the millennials and the post-millennials, who we like to shit upon all the time. But we actually, for me personally, there is a lot we can learn from the millennials, from these post-millennials, their approach to gender rights, their approach generally to, cultural appreciation. I just want to point this out, that all of you are probably already ahead of the curve. You'll think about the environment. You'll think about things that matter in ways that many people in my generation probably did not. And I just urge you, younger generation, we're screwing things up in many ways, like the environment, like the financial system. But you all have the responsibility when you see wrong things happening, when you see a woman or a person of color being disrespected, even more likely a woman of color being disrespected, don't be silent. You have a special responsibility to call out that behavior. Very often calling it out itself can help remedy the solution. I'm pivoting a bit from your topic, Damian, but I thought it was important and I should share it. I will stop here in the interest of time.
Absolutely, that was fairly motivational. I really appreciate that. And just to clarify, I am not a serial killer, and I am quite happy to eat pizza with you at 2 a.m. in the morning. So I think the flavour we're getting is that we're all talking of respect and courtesy and trust and faith, both in your colleagues and yourself, and definitely having a confidence in your own ability. I think, Kabir has said that, Anish has said that, Isaiah has said that. I want to drift away a little bit from the norm and talk of the reality of that appointment, because, as we sit here now and without your first appointment, it's very exciting getting your first appointment. But when you do get that appointment, and we can hypothesize as much as we like, but in real life, nerves, human nature, everything takes over. And one, I'd like to address you on this because, again, you're a female working in legal disputes. You have a cross-cultural ethnicity. you know, has this caused you any issues in cross-examination or during a hearing, or, you know, can you share anything?
Yes, actually, I think it's a good anecdote to share, because you would think, oh, you know, you're a white lawyer, you know, grown up professionally in Switzerland and France. So, you know, when I got my first cross-examination, you know, or usually it comes after a little fight to get to there, you know, convince the client, convince the co-counsel, and so on. So I remember that I had tried to convince the partners and then the co-counsel that, you know, they should let me do this cross-examination, because, you know, yes, I'm young, yes, I'm a woman, but you know, the witness might relax, you know, and, you know, be not too impressed by me, and, you know, so I tried to convince them with these arguments, which are not so good, but anyway. And then, so I was doing the dry run, and the co-counsel, and I was cross-examining a witness who had not finished even high school, you know. He was not high level in the company nor anything. He was more in the factory or in the trading office, I can't remember. And the co-counsel said all of a sudden, but you know what, he was not that interested in what I was saying, but he said, you know what, it's really good that she's cross-examining this witness, because he's gonna be very offended to be cross-examined by someone mixed. And I was like, well, I was expected by a woman, by someone, by an intern, because I look young or something like that, but by someone mixed. And I remember that it shocked me, because I really was not expecting that one. But it also reminded me that it must happen every single day to people who are of color, or like, I don't know, like have a handicapped or are handicapped or something like this in the office. They must have that every single day. And I feel this is something that should really, really change now. So yes, I think, thank you, Kabir, for saying these attitudes have to be called out systematically. And I hope that at some point it comes from the old partners. My hopes are not so high. So I think it's for all generation, you know, now that we get in positions where we can speak up, you know, like I'm like about 10 years of experience. I think that at my age, I should not let these things be said, you know, without speaking up. So yes, it's a responsibility for all of us for this not to be an element that people should consider when they are pursuing a career in arbitration. We are doing arbitration, it's international, and I think it's really bad that people get these experiences, you know, when they try to get in the industry. It's really contrary to what international arbitration is for me.
Yeah, well, I mean, from my perspective, working in arbitrations, I'm sorry you've had that experience, but I think the important message is that your strength of character has seen past that, and whether that's just as an individual or as a woman of cross-cultural ethnicity, you've been strong enough to develop your career and continue and see beyond that. So I think the change will come from people like yourself in the development of that whole situation. So thank you very much for sharing that. It's a fairly personal situation to allow people to see into today. So thank you, Juan. Janice, we yet to see the puppy appear, but from your perspective, you have already had some great experiences in arbitration. Could you possibly share with us the quality you have admired most in an arbitrator from a practical perspective, and perhaps whether you have adopted this approach in your practice?
Thanks very much, Damian. So I think personally for me, in terms of the quality of the arbitrator, I mean, as an arbitration counsel, and even before when I was in SIAC, we have seen a number of different kinds of arbitrators. And, you know, at one point you would think that, you know, there's a certain kind of standard that should be followed by all of our arbitrators, but sadly that's not always the case. So personally, of course, I think that the best quality is a certain level of competence, you know, an undeniable grasp of the law and the facts of the case. But I guess most important for me is really somebody who is conscientious, somebody who is able to understand that what they're doing is not simply a job. It's not simply something that pays the bills. It's something that really affects many lives, because when they rule upon a dispute, when they rule upon somebody's case, whether it's investment or commercial, it really impacts, for example, the client's business. It really impacts that business's employees. It has so much more wide-ranging impact than just simply, it's not just a case that goes to court eventually to be enforced. So that is something I really think should be a quality that many arbitrators should not lose sight of, is being conscientious of what the significance of your role is when you are appointed as an arbitrator. It's not simply, oh, I'll apply the law. It's not a very mechanical, application of these are the principles, these are the facts, and therefore this is the result. There has to be an awareness of the impact that you have. In the same way that, many judges in national courts, we hope has the same kind of awareness. Now that we have transplanted the dispute resolution process into a private mechanism, for me, it's really very important that that particular arbitrator or whoever is appointed understands that kind of impact, the kind of, in a way, a social contract that is imposed upon that person when you're being asked to decide a dispute.
Thank you very much, Janice. I think one of the important things I've learned, and I only work in particularly technical arbitrations, whether I sit or I am before an arbitrator or a panel of arbitrators as an expert, is the most impressive quality I see is the management of the whole process in this very impartial way, and almost extolling the virtues of natural justice and letting each party have their say and their right to be heard, but managing it in a very, very nice way. And there is the part of it where it's like actually sitting before your uncle and having a chat, or your aunt, and having a chat with them type thing, and you feel sort of comfortable. You don't feel impugned. You don't feel sort of embarrassed because you're not the cleverest person in the room, and that's always a big thing in arbitrations. I think that's a really good quality of an arbitrator, somebody who can listen and can understand.
Damian, would you mind if I just add a point to that?
Yeah, absolutely, please.
Yeah, absolutely. So Janice, excellent points. Just to pick up on that, one of the qualities I like is an arbitrator once told me when they write an award, they try to write it in a way that they write the award for the losing party. So that speaks to this conscientious nature you were coming about, and what Damian just touched on as to the caring uncle. Your caring uncle can tell you off, and you understand why he's told you off, and you don't take offense to that. So he told me that the winning party will often just go to the dispositive and say, well, how much am I entitled to? We're going to enforce. Whereas the losing party will go through line by line and to try to find any reason to challenge your award. So I think an excellent quality is that ability to write this award for the losing party, as it were. So just picking up on the caring uncle or aunt point you made there, Damian.
Thank you,
Damian. If I may also just supplement a few seconds what Isaiah just said. Great points by Janice and Isaiah. And just to sort of reverse the question a bit, one of the qualities that I saw that I didn't like when I was doing the work of a counsel before I became a full-time arbitrator and mediator in 2016, when I was playing the role of counsel and working in law firms, I noticed that many arbitrators don't respect the fact that being an arbitrator is a privilege. It's not a luxury. It's not a free-for-all. And I noticed that arbitrators used to fix a session for 6 p.m., but wind up more often than not in the Indian and Southeast Asian context by 4:35, saying, oh, we're tired, and not bothering about the cost that would involve for the parties having another day hearing. And for me, when I became an arbitrator, I said, this is a quality I never want to have someone attribute to me. And I'm going to fight very hard to change that mindset and perception. And one of the reasons for that was also to make the losing party feel a sense of satisfaction. So I remember once, on the last day of hearing, after about 7 days, one of the parties wanted another 2.5, 3 hours. And the other party had no objection. And they said, oh, can we reconvene the next day? Now, the next day, I already had another hearing in another case fixed months in advance. And if I had allowed that hearing to continue, yes, I would have made more money as an arbitrator with my allowance, XYZ. But it was an unconscionable thing for me to do, to just for 2.5, 3 hours more, 4 hours more, to fix another date of hearing, because it wouldn't have only been additional travel expenses and costs for me, but for the parties, the lawyers traveling. So I said, look, gentlemen, I don't care if you sit here till midnight, till 1 a.m. You'll want to eat your dinner in front of me, eat it, but we're not moving from this room until this finishes today. And we sat that day, I remember, till about 1:15 a.m. And we had started at 9 a.m. that day. And I remember at the end of the arbitration, about a year later, the lawyer who was representing the losing party came to me and they said, our client was, though they lost, they never challenged your award. I said, oh, I was quite surprised because it was a significant sum. And they said they felt a sense of satisfaction that they were being heard. They were given an opportunity to present themselves, that the arbitrator made them feel as if they were doing justice and being balanced to all, responding timely to emails. Even if it's a simple one-line email to say, I have received it, I should respond by X date, gives parties a sense of satisfaction, and that's so important.
Absolutely, absolutely. I think some really, really strong points there. The caring uncle. It's better to be told off by your caring uncle than your dad sometimes, I think, and that's the important thing. I think arbitrators who write awards that tell the losing party how well they have argued, yet they're still lost, and the losing party actually walks away quite grateful that the arbitrator considered every argument of defence they put up. It's an important quality as well. Kabir, if I may come back to you now, I'd just like to take your thoughts on the future then, on the whole premise of arbitration and the lack of physical hearings that may ensue in the post-COVID period. And I mean, obviously a big point for our attendees today, our guests, is the demand for arbitrators. Is the appetite for parties who want to be heard in arbitrations and physical arbitrations, will that dampen by moving these to virtual hearings? Does the virtual hearing have the same essence that you want from a physical hearing? How do you think it'll go? Do you think demand will increase because virtual hearings can be carried out quicker? Or do you think parties in an arbitration actually do want the caring uncle to listen to them and feel that they are listened? And that deviation from the court process where you basically go into court, carry out your pleadings, and you are told that you are right or wrong. An arbitrator does it in a slightly different way. Do you think that's going to change? Do you think people will be happy with virtual hearings?
Let me give a couple of thoughts that I have. It's not very structured, but I'll try my best to put it in some seeming order of intelligence.
It's early in the morning for you, so. Yes.
Point number one, I think right now, the worst idea for most people is the idea to get on a plane. So I think at least in the near to not so near future, we're going to be living in a virtual reality. In some senses, we should think about this virtual reality as a great equalizer, right? You otherwise had to travel to these very expensive hubs. We're in many senses creating greater access through allowing things to happen virtually. So to that extent, there is something positive that we should take out of it. It also gives greater access to groups that were otherwise not getting the opportunity to represent themselves. So hopefully we're nowhere close to addressing the gender gap in our profession. Hopefully COVID helps us rethink that in some senses, Is it ideal? It could be ideal. Some people tell us cross-examination is much better when you do it virtually. I have two screens in front of me. One of the screens has the face of the speaker blown up. Damian, that is you right now because you were the person who just spoke. Really, you can't see it, sorry. You're blown up in front of me. And for cross-examination, people say that helps. You can actually see things the way you never could. There are pros and cons to anything in life. Where do I really see the issue? I really see the issue when you're in a national. Imagine if you have a party from Australia, you have somebody from, say, Turkey, you have somebody from Latin America, and you have somebody from Canada, right? That's not uncommon in the reality that we are. Now, in this situation, your hearing cannot be more than 4 hours a day, or somebody is forgive my French, going to get screwed. Somebody's going to have to stay up late. And you probably don't want to do that because then you will get due process arguments. So in situations of that nature, where you have real time differences, you know, your hearings are going to get pulled out for a longer period of time. But, you know, I look at this reality of how people moved away from, you know, horse carriages to cars. You know, I'm sure they were having COVID discussions that we have. Can we do it? Will it survive? But the reality of the day is we have to embrace technology. Damian, it looked like you were going to say something and I should stop.
No, I was just going to make the point that at the time when cars replaced horse carriages, there were people who said that cars will never survive, they will never be successful, never.
We have to embrace technology. The idea of virtual hearings has been around for I shouldn't say, well, many, yeah, we can say many. It's relative to what I had in mind, but it's been around. It's not a new idea. COVID has forced us to embrace it, but the idea has existed. And, you know, I think we will see a greater acceptance, a greater willingness not to travel, which there are advantages for the environment. You know, it will create this greater access for groups that don't get it. So, you know, glass half full, let's try to be optimistic and hopeful.
Yeah, no, I agree with you.
If I may.
Well, so, sorry, who's coming in?
Hey, yeah, I quickly wanted to pick up that point about how what Kabir was saying with regards to, you know, virtual hearings providing greater access. And I think there is, to a certain point, accessibility has been made a lot easier by the virtual platforms, this webinar being a perfect example of that. I probably wouldn't have been there or I would have had to fly so many hours and, you know, I would have to think about, can I afford to do that time-wise, financially, like what are, you know, so it does definitely take that out. But there's something that I'm seeing that I think is a bit problematic, which is with regards to countries that don't have the best infrastructure or even the stereotype of certain countries not having the infrastructure. And I would particularly focus on African countries or developing countries, for example, where there is an argument of saying, well, should we appoint this arbitrator who is based in, you know, insert African country name where internet, you know, is unreliable. And 2 weeks ago, the government shut down the internet for about a month. So can we really do that? And that will cost the hearing XYZ amount more time and whatnot. And I've seen that come up a few times. And I'm not saying it's not wrong, but I'm just saying it's also another structure. And unfortunately, because of development related issues, it does create another potential shield from, you know, just sticking to whatever region or area that you're in. And that doesn't mean diversity is not going to be an issue, but I'm just saying in terms of physical placements, that could also be a limit to some of us.
Yeah, there will be challenges and those challenges will develop as time passes and we will get better at this. I think one thing we did learn from Kabir there is that we must improve our poker face if we are ever before him. He's watching every twitch that we make. So Isaiah, if I can come back to you now, and obviously keeping to the nub of the webinar itself and our young arbitrators and navigating the international waters. If the young or even younger Isaiah was attending this webinar today, and he took away from this, I'm so inspired by these great speakers and that fantastic moderator, Mr. James. I'm going to be an international arbitrator. I'm going to study abroad, albeit virtually. I'm going to take on an internship. I'm going to network, I'm going to write articles, and I'm going to be the standout arbitrator in 10 years. Would you say that was a reasonable expectation for the young Isaiah?
Damien, great question. I mean, the natural answer would be, a biased answer would be, oh yeah, absolutely, I want to be an international arbitrator, but the reality is quite different. And I actually saw a question in the Q&A as to what was the gap between us getting accredited, perhaps on the CIArb and getting your first appointment. That's an excellent question. I think you have to face the realities of it. Leyou made the point that would a client want to appoint me? Are they sure that I'm experienced enough? Are they sure that I have enough expertise? And that's a problem that a lot of young practitioners face. So if you look at the data, for instance, what is the biggest driver for arbitrator appointments? There was a survey about 4 or 5 years ago, and 95% of respondents said expertise and experience. So for young arbitrators, you're in a catch-22. To get appointment, you need expertise and experience, but you can't be appointed until you have expertise and experience. So the advice I would give myself is to leverage on my network a lot more. And I only discovered this probably in about 2012 or so, when I attended the IBA conference. And it was one of my very first. So I attended this session on how to navigate the IBA conference. And one of the speakers said, you know, when you go to these events, many people think focus on the plenary sessions, focus on the panel discussions. And she actually said, no, actually, if you miss all the plenaries and all the discussions, never miss the networking sessions, because that's where the real connections happen. So really leverage on your networks. Your network can open up a lot of opportunities for you. You know, I have some very good friends on this call, Leyou, Anish, who have opened opportunities for me, and I hope I've done the same for them. I'm making new connections on this call, which I hope I can leverage on it. So Damian, I'm looking at you in terms of construction disputes, and and you know, but in all seriousness, I would say never underestimate the quality of your network. No matter how experienced or inexperienced that person may seem, they will always be useful to you. So remember that, leverage on your network, make the most of opportunities that come your way, and you will grow from that.
Absolutely, Adam, that's excellent advice. I really do. And 2 points you pick up upon is obviously in terms of the big drivers for arbitral appointments. I'm not saying the easier access into, I think one of the questions asked the question is, one of the questions deals with this, and you picked up on it yourself, is your entry into arbitration. How does it come around? I mean, it's been slightly different for me. Obviously, I took qualifications quite early in my career, and I was working within the Construction Act of the UK from 26, 27 years old. But it wasn't until I actually became recognised as an expert that my arbitration appointments started to flow. And that was because I had networked inadvertently in a subliminal manner before arbitrators and before panels and before parties, contractors, employers, providing technical expertise in terms of quantum and delay. So when matters came around on a very technical basis, quantity surveying, etc., I became a relevant choice for them. You know, so I'm slightly biased by that whole effect that I have the technical side of it without using the judicial side of it. But that is part of the journey. And like you say, it's developing that technical aspect. And you can do that in law as well. You know, there's all sorts of aspects of law you become particularly qualified in, etc. So that's really good. And obviously the networks, I mean, obviously the young Isaiah would like to drink more than he has done in the past and eat more pizzas at 2 o'clock in the morning. But I think the important part of networking is that when I first started networking, and I can only draw on my own experiences in this respect, just to reflect onto the listeners, is that I originally thought that we were all stuffed shirts and we all talked in a certain way. And, you know, when you had a glass of wine with someone, you would talk about the New York Convention and, you know, the effect of this, that, and the other, and what you thought of the latest changes to the ICC rules and stuff. And what I find is that people just generally want to know who you are and have some honesty about you, so they have some connections, so that next time they are at a networking event, they can talk to you. I mean, you know, think about it this way. If every time you spoke to somebody at networking events and you talked about Hadley versus Baxendale in 1868 in the English law, would you want to talk to that person next time you saw them? I think in my experience, I'd be thinking that's the chap who talks about Hadley versus Baxendale all the time. There's a chap over there that I know from Nigeria, Isaiah, he talks about cars and he talks about suits and he talks about football, and we have common interests, you know, and he's a jiu-jitsu champion. So, you know, I'll talk to him today. Anish, you can come back in, and I think taking on again, you know, and taking on the young guys, if you were to find yourself starting your ADR career, and I know you've started 2016 and pre-2016, and you wanted one piece of practical advice other than networking, which Isaiah lent to us, what would it be? If you had the opportunity to talk to an international arbitrator now and say, what advice, I've never had an appointment, I've not worked in the international arbitration, but in 10 years I want to be you. What form of advice would you want?
Thank you, and that's a very, very good question, because the one advice if I would give myself and I would want is, and this goes back to a bit about what Hoang said earlier and what the other panelists said earlier. I made the mistake starting off thinking that it's important only to focus on the big hubs. If that's where I'm going to make my mark, the excitement of being an arbitrator in Paris, in London, Geneva, Singapore, Hong Kong, the excitement of all of that. But I realized that, as Leyou and everyone said, that it's an old boys club. It is a very, very closed clique. And what I realized on my own, the hard way, and again, when I use the word relatively easier, to break into that, to earn that respect, to make your mark and headway, is focus on the lesser and the smaller jurisdictions, where the mafia isn't that prevalent, where you will have greater scope to prove yourself. You'll have greater opportunities. And because of that, when I started doing that, that's when I saw the evolution. That's when I saw the change take place. Because like, Hoang mentioned earlier, people in these very advanced arbitration jurisdictions are looking for people with unique traits, with unique qualities, accreditations, understanding of jurisdictions. I mean, I was recently approached or rather interviewed for an arbitration seated in Switzerland, where they wanted someone who understood Kazakh culture, in Kazakhstan. And because of my cultural, though I'm Indian by nationality, ethnically I'm Zoroastrian. The Zoroastrian culture is very similar to the Kazakh culture. And they would have never known this about me had I not been qualified in these other lesser known jurisdictions in that sense. So that's the advice I would have really wanted, because I spent a lot of time initially focusing on these bigger jurisdictions when I should have just focused on developing myself and my qualities. And the other point, very importantly, and I think this pertains to one of the questions raised in the chat, we simply can never, ever, ever think that merely by getting an accreditation or a qualification that we will get an appointment. It's what you do with what you have. You could get an LLM from, Harvard, Oxford, Stanford, the MIDS LLM, all of that. It would mean nothing if you don't make use of that in a proper way. And like, I completely agree with Isaiah, that network, because see today, what I've noticed a lot of, and what perhaps I did when I was younger, about 8, 9 years ago, 10 years ago, when I networked, I looked at that as an opportunity. Okay, maybe I can get a job here or I can get some work, but that's wrong. What I learned is network to forge a bond of friendship and a relationship with the person. And when you do that, that bond is unshakable, because earn that person's respect. Because see today, let's say for example, Damian, you're at a conference and people don't know you, but when they meet you, they believe you talk about yourself, who you are as an individual, and they trust that person. They will remember you. Here's this person in South Africa. We need an expert. Let's appoint him because I trust this person. It's the same way today. I've been very fortunate. I've recently been appointed as a sole arbitrator in a case involving Chinese law, and it's about building that rapport and that trust. Even if it's something unknown. And I think that's so important. And that's, I would have saved a lot of time and, a lot of having to navigate difficult waters if I understood that better.
I think the key point that I take away from what you said there is that networking, as Isaiah said, and as I've said, is important, but it doesn't render immediate results. It renders long-term relationships and partnerships and people that you remember and people you can call upon in the future. So networking is important, and giving of yourself is important. And I think, we talked about the core values of, trust and faith and respect and courtesy and confidence. I think when you have confidence in your own ability, then you don't need to talk too much of the Geneva Declaration or the New York convention, etc. You can just be yourself, and that harnesses those relationships. Leyou, there's a question in the Q&A which is probably not dissimilar to what I'm going to ask you now, and it's really a two-part question. In terms of your career, you know, what's been the biggest challenge that your career itself, not you as an individual, but your career has faced? And I don't mean your presidential campaign in Ethiopia. And the second part is, and you seem, I see you as someone who's, you know, ethereal and conceptual, but what's been the most powerful thing you have heard in your career?
Thank you, Damian. Well, in terms of some of the biggest challenges, I mean, a big challenge to my career has been, it's been an asset and then at the same time, a challenge, which is, you know, being based in Ethiopia has been a bit of a challenge, because we've talked about how being based in the arbitration hubs, or even having easy access to the arbitration hubs, does create a certain level of opportunities for you. So to even get internships and whatnot. And that was really a big challenge. I went to school at Georgetown. I did my LLM at Georgetown. And after that, I had the opportunity to work at the World Bank. But part of the, you know, the challenge, then I moved back from there. And the challenge for me at that point was, there were absolutely no, and this is in 2009, and there were absolutely no arbitration related or focused spaces in the African continent. Everything was either in Paris, London, and New York. So it was really a really big challenge, you know, and in a way, I think, perhaps as an inspiration to the young ones that are listening today, is what I did was, and, you know, and I didn't know that much, you know, then, other than having an arbitration LLM, we started an arbitration conference. Which is now in its 9th year. And we started having 60 people that first attended our very first arbitration conference in Addis Ababa in this very small hotel. And we were so happy we had 60 people, but now we have 500 people attending and we've moved to all the different cities in the East African region. And so something like that was absolutely helpful. And it has created a platform where I met Isaiah. I've met arbitrators from South Africa. I've met arbitrators from Egypt. And that was really a big challenge, because even when you look at the African continent, our practice is not continent-wide. Our practice is very jurisdiction-based. So if you're a Kenyan arbitrator, you're going to be in Kenya. If you're an Ethiopian arbitrator, you're going to be in Ethiopia. So there's no cross-boundary. And I think having built a platform like that, and I-Arb Africa, my online platform, is also birthed from that lack and that challenge in my career, which is I need to know what was happening in Angola. You know, and that was extremely helpful, because I made myself very useful to different platforms and different people, because I knew what was going in a Pan-African sense, not just in an Ethiopian sense. And that really came that was, I think, my biggest advantage. And whenever I'm invited to panels, and whenever I'm invited to work on a case or help with a strategy in a case that concerns an African party, it's because, not because there's an Ethiopian party in it, it's because there's, oh, Leyou has an understanding, the Pan-African understanding of what's happening. So she'll be very helpful in designing that strategy. So that was a challenge, but then it's a challenge that birthed my career, to be honest. And to your second question, I kind of want to mix it with the question you had asked earlier, which was, when you're going into an arbitration, your career precedes you. One of the best things I've heard, the best way an arbitration award being described, and it says by this very established Italian arbitrator. And he said, you know, an arbitration award is a negotiation. It's a negotiation between 3 arbitrators or more, right? And a negotiation can truly happen among equals. Because if you're not equals, you're not negotiating. Somebody's being dictated. And it's a majority rule, right? You have 2 arbitrators agreeing to one side. The other arbitrator can easily be sidelined. And there's a lot of that happening currently. And whenever you look at, you know, our appointment of African arbitrators, you see a lot of sidelining of a lot of times of the diverse arbitrator. And what I've learned from that is being knowledgeable, having what precedes you is your career and your integrity and what you know, but being extremely useful and being extremely knowledgeable on the matter makes you an important part of that arbitration and does add value to your kind of balancing you out with, when you have arbitrators from different, regions who are extremely, knowledgeable of the area or have had so much experience. When you come in as that breath of fresh air, but also one that actually really understands what's going on in the region, whether it's the governing rule, whether it's the center, whether what it is, when you come in with that technical knowledge that you were talking about earlier, Damian, it really does add such a huge factor. And you start getting considered as somebody that, does contribute to this award. You're not just sitting there and listening and taking just, experience. You are also providing your perspective, and your perspective will actually have an impact on the outcome. And I think, these are the two main things that I've learned. But I will add one more thing, which is, I remember I was having a discussion with regards to the ICSID rules amendment. And so I was advising the African Union on the rules amendment. And, we were having a discussion. There was one particular rule in the ICSID amendment rules. And I said, I don't think this is something that the African Union should really consider before we start supporting it and our member states start supporting it. And the first kind of the reaction that I got from a lot of the member states, African member states that were at the meeting in DC was, wait, we haven't seen that. That's not a problem. That's not a problem. And I had to actually write something and spread it and give it to all the different countries to say, this is how you are going to be affected. This is how your interest is going to be affected. And doing that and going out of my way to do that has put me in a position where I now have attorney generals from different African countries saying, hey, Leyou, have you seen what's happening in this and that? And it's not because anybody paid me. It's because I am doing it because I truly believe this is something that's in our interest. And so that integrity does follow you wherever you go. And I think that's really helpful.
Brilliant, absolutely fantastic, that, Leyou. Thank you very much. In terms of where we are now, we are 4 or 5 minutes away from the close. I know we started a little bit late, so I'm not sure whether the chair will allow us to run over slightly longer just to run through the questions, if that's okay. And I think I'm gonna just go to the question and answer sessions, and the question and answers and the ones that we have, and maybe I can ask each of the panel in turn. There was a question from Audrey Kakamoto, which said, for all the panelists, how long after accreditation did it take to get your first appointment? Janice, could you give us an honest and open answer in terms of how long it took you?
Well, my honest and open answer is while I have been accredited and impaneled in a number of different institutions, I have not had my first appointment. So I think this is something that, we've been discussing, that you can have everything in place, but sometimes there are a number of barriers as well to getting your first appointment.
Absolutely. Isaiah, what impact on a scale of 1 to 10 would obtaining an LLM have propelling one's career in arbitration?
I think Anish addressed this point earlier. Actually, it's not actually obtaining the LLM, it's what you do with it. So if the LLM can be used as a platform to demonstrate your ability in a particular area and you think it will serve you well, then by all means go for it. I know people, for example, who do not have LLMs, who are not accredited with arbitral bodies, but are doing very well in international and domestic arbitration simply because they demonstrate their capabilities in whatever platforms they find themselves. But if you sort of have a look at it and you think an LLM will benefit you in demonstrating your expertise and your competence, then by all means use it. But simply don't go for it simply for the sake of having it.
Absolutely. I think that's a really good point. Leyou, what other grounds, I need you to keep your answer short because I feel that you could answer this for the next 30 minutes. What other grounds of bias against young African practitioners that can probably be cured through skills, acquisitions, etc.? Is it academic or experience or working in the arbitration hubs? What are those grounds of bias against young African practitioners?
Honestly, yeah, we can say skills, we can say experience, but what I would really say is having a tribe. And I think that's something that's really important. Having a tribe of African, not only just African, but having a tribe of arbitrators or practitioners in the arbitration space that know you, that have mentored you, that are invested in your success, and having a tribe that supports you, that you also open doors to, but also open doors to you. I think that has been the most important thing for me in moving my career forward. I mean, I had the skill, I had the knowledge. There's many of us that have the skill, the knowledge, the experience, the exposure, but are not able to make that move forward because we do not know people. And because we don't have people that are vested, have a vested interest in us being successful. So as we have open doors, because we do have access. And that's one thing that we also forget, is that we forget that we have the power of access because we have connections within our jurisdictions, within our countries that are huge cases or appointments for those that are outside of the country. Same way that those that are outside of the country can actually also open doors for us. And I think that's really what is important.
Excellent, thank you. Kabir, as our probably most learned panel member, are there preferred journals and magazines in which you could look to enhance your intellectual reputation?
I mean, look, there's no dearth of avenues to publish. You know, if you're starting off, you're probably better doing two things. You're probably better publishing blog posts. Kluwer Arbitration blog is a great place to begin. Another avenue just in the idea of networking is, you know, reach out to people who are senior and propose co-authoring with them things. Do it well, do it, you know, put your best foot forward, but you do realize the way the world works. You're going to draft everything and you will be the second author, but that can be a good way to establish yourself and build your credentials and gain some goodwill. You know, so these could be some options. Professor Google will give you 9,000 journals on arbitration. Go there, you will get them. You know, there's no dearth of them. But do it thoughtfully, do it professionally.
Absolutely. Anish, what are the best kind of events? You've talked about networking. What are the best kind of events to keep an eye out for if you're trying to network and meet more people in arbitration practice?
I can tell you what I did. So when I decided to take the plunge and become a full-time arbitrator and mediator, for the first year in 2016 till mid-2017, I attended every single ADR related event I could find, both in India and overseas. Attended them all. The main reason being, A, to understand the market, the circuit, who's who, how people are, understand the different people, the different cultures, how the senior individuals talk. And, you know, like everyone said, that through that entire process, I learned and I sat back and absorbed as much as I could. Attend as many as you can. And then you filter it based on, well, in pre-pandemic, budget a certain amount each year. And now in the post-pandemic, where a lot of things are virtual, attend as many as you can because you will learn. You get an opportunity to network. For example, you can, if you like what a particular speaker is saying, reach out to them on LinkedIn, drop an email saying, well, I love what you said. You know, I'd love to co-author something with you, like Kabir said. And that's a great way to get that exposure. So as many as you can.
Excellent. One, you answered one of the questions already in the Q&A session, so I will put a question to you, just myself then, and don't worry, it's not a trick question, but if you could answer it honestly, that would be great. What did you learn about yourself in quarantine and lockdown?
Well, I don't think I learned so much. It just confirmed that, yes, I do have a tendency to basically, I'm an arbitration lawyer, so I live by deadlines, you know, so it goes very well when I have a deadline because I'm gonna be like sweating until the deadline like I would be in the office. When it is about working on the case in which the hearing has been postponed by 13 months, yeah, I have a tendency to procrastinate, and this has been confirmed at home. Yes.
All right. Well, thanks for that honest answer. To you as a panel, it's been an absolute pleasure to moderate this webinar, and thank you for an immensely enjoyable session. My sincere gratitude to you all, and I hope we have an extensive relationship in the future, which is an important message that we've delivered here today. I'm going to hand back to Jay to close, if that's okay, but thanks again to you all, and thanks to all the attendees for listening. Thank you very much.
Thank you very much, Damian. Again, thank you for the time. I wish to thank everyone for the time for joining us today at actually the inaugural webinar of the Chartered Institute of Arbitrators East Asia Branch Young Members Group webinar series. I hope that everyone found the webinar informative and helpful. I certainly did. And everything that was discussed gave me flashbacks from a time before I actually had my first appointment as an arbitrator. And that was a time when an arbitrator told me that I will have to lose my hair first before I get an appointment. Well, thankfully, I got my first appointment before that happened. Everything that was discussed earlier, the knowledge, expanding and taking care of your network, experience, the quality of work, commitment, these are all crucial, I think, in making a career in arbitration. However, at the end of the day, as Anish said, it will really depend on you because you are the driver of your own career. It's really up to you on how you use all the tools and tips discussed during this webinar. That said, I wish to thank and give a shout out to the organizing committee of this year's webinar series, composed of some of the best young ADR practitioners in 8 Asian jurisdictions. We have the Young Philippine Institute of Arbitrators from the Philippines. We have John Lumban Tobing from Indonesia, Loshini Ramar Muti and So Wei Lim from Malaysia, Janice Lee, of course, in Singapore, Ronald Pang and Edward Chin from Hong Kong, Anish Wadia, of course, from India, Syed Mustafa from Pakistan, and Felice Liu and Allison Chang from Taiwan. The webinar series, this is the first of the 8 that we will have. The series is indeed the fruit of an international collaboration. And so I'm very honored to invite everyone to also support the next 7 webinars that are part of this webinar series. And I think that's now being shown in your screens right now. Earlier, I shared the link where you can get more details about these webinars. And from this link, you can also register for free. Finally, I wish also to thank our co-organizers, Kizumbing Torres, a member from Baker McKenzie International, and Young Philippine Institute of Arbitrators. If you have any feedback or wish to learn more about the events of these organizations, please feel free to follow their social media accounts, whether that be on Facebook or LinkedIn. Just a reminder that this webinar series was organized in lieu of the 2nd annual conference. This year's host is the Philippine chapter, and I'm happy to announce that next year's host will be the Taiwan chapter. Once again, thank you for supporting this webinar, and we hope to see you in the next one. Again, that's on November 6th, 3 to 4:30 p.m. Hong Kong time, and the panel discussion will be entitled China's Influence on ADR. Enjoy the rest of the day. Thank you again.
Hi, everybody.
Right, are we now off? Thanks, everyone.
Thank you all. Lovely seeing each of you.
Thank you, everyone.
Thank you very much. It was nice to meeting all of you.
Bye-bye. Well done. Thanks, everyone.
Thanks very much. Goodbye, everybody.
Bye.